Hi guys, welcome back to my channel. So today in this video I would like to read an article entitled The Interface Between the Insolvency and Admiralty Jurisdiction. Bank of Tokyo, Mitsubishi UFG V, owners of the Sanko Mineral and another Sanko Mineral 2014 EWHC 3927, Admiralty 2015 EWHC 1031. Two recent decisions issued by the Admiralty and Companies Court in London highlight important issues following the arrest and judicial sale of a vessel owned by a company that is subject to foreign insolvency proceedings. The decisions highlight two important practical lessons for shipowner and shipper alike. The first is the importance of protecting time limits for the commencement of a cargo claim even when the carrier becomes insolvent and the claimant has submitted their proof of debt in the foreign insolvency procedure. The second is the questions of Admiralty practice in respect of the timing of issuing an interim claim. The background fact: in July 2012, Sanko Steamship Co. Limited entered into Japanese insolvency protection following a period of financial difficulties. The Japanese reorganization proceedings were subsequently recognized by the English Companies Court as a foreign main proceeding under the Cross-Border Insolvency Regulation 2006 or CPIR. This affords Sanko protections from creditor or other claimants seeking to commence or continue legal proceeding against Sanko via the English court or via arbitrations with its seat in England. In April 2014, Sanko gave permissions for the mortgage bank to commence proceeding against the MV Sanko Mineral, which was at the time in UK waters, such permissions being required as a result of the stay that had been put in place on recognitions of the Japanese insolvency proceedings. The bank issues interim claim in the English Admiralty Court and the vessel was arrested. The bank obtained judgment on their claim and the court ordered that the vessel be sold and the proceeding to be held in court pending determinations of priorities. The order also provided that the sale be advertised with a notice that all persons having an interim claims against the vessel were to apply to the company's court or seek permissions from Sanko to commence their claim within 60 days of the notice. The vessel was sold on 7 August 2014. On 22 August, Glencore applied to the company's court for permission to commence a claim interim and also issues a caution against release of the vessel in the Admiralty Court. The term of the cautions provided that Glencore claim was secured by a maritime lien over the vessel. The maritime lien was said to have arisen as a result of a claim made by Glencore against the vessel in the US under a bill of lading, following the delay in delivery of a cargo as a result of the attachment of the vessel by creditor there. No other creditors sought permissions to bring in an interim claim, as there were sufficient assets from the proceeds of sale to satisfy both the bank and Glencore claims. Funds were released to the bank with the remainder being held by the court pending a further order. Glencore had previously submitted proofs of debt in the Japanese reorganization proceeding for a secure and indeed alternative and unsecure claim, for some said to be owing to them in respect on the delay in the delivery of the cargo in the U.S. Both claims had been rejected and were subject to appeal to this Tokyo District Court. At the time, caution was filed. Issues in dispute. Sanko applied to the Admiralty Court for Glencore caution to be struck out and for the remaining fund to be paid out to the trustee. The ground for the applications were: 1. Glencore claim under the Bill of Lading was time-barred as they had not commenced arbitration within the 12-month contractual time limit provided for therein. 2. Glencore claim was not a maritime lien as a matter of English law. And 3. Glencore had no issued an interim claim from prior to the sale of the vessel, meaning it was no longer able to enforce its interim claim as Sanko were no longer the beneficial owners of the vessel. In response, Glencore argued that the whole contractual dispute resolution clause, including the time bar element, had been supplanted by the insolvency procedure in Japan. As Glencore had submitted to that procedure in due time, they argued that there was no additional requirement for them to make a claim in London arbitrations as provided by the contractual dispute resolution clause. Glencore also argued that the basis of their claim in Rome was the recognition by the English court of an order of the Tokyo District Court admitting their claim, which could be enforced against the proceeds of sale. Time bar issue. The court held that where a contractual time bar provisions requires arbitration to be commenced in order to preserve a claim, failing which the claim is absolutely barred, that provisions must be complete with. If it is not, that as a matter of contract, the claim is barred, where there is an insolvency procedure in another jurisdiction, then Article 20, Part 4 of the CBIR permits proceedings to be commenced to the extent necessary to preserve a claim. Therefore, Glencore could have commenced London arbitrations proceeding to preserve their claim at any time in the relevant 12-month period, but did not do so. As a result, their claim was, as a matter of contract, absolutely barred by September 2013. The court was keen to emphasize that the questions of whether Glencore were entitled to pursue their claim in Tokyo District Court, notwithstanding their failure to commence arbitrations, was a question for Japanese law and the Japanese court. Admiralty practice. The court held that the claim contemplated by Glencore, in example, the enforcement of any subsequent order of the Tokyo District Court against the proceeds of sale, was not a claim which could be pursued via admiralty actions in Rome. It was irrelevant whether Glencore had an interim claim under U.S. law. A cargo claim could only give rise to a statutory maritime claim, and the cargo claim was time-barred. So the time is up, and the article will be continued to read in the next video. So bye bye, and don't forget to like, comment, and subscribe. Bye.